Okay, so good afternoon, everybody. Thank you all for joining us today. My name is Shamika Dwarka, and I am the Pro Bono Development Manager at PILA. Can I please just ask everyone to keep yourselves on mute for the duration of the presentation? You are, however, welcome to keep your video on if you'd like. We are joined by Cillian Bracken BL, who will facilitate the session, and we are very grateful to him for this. Cillian is a practicing barrister specializing in public law and judicial review in the areas of immigration and asylum, employment and equality, social welfare, housing, and data protection. For today's session, we will commence with the presentation covering the salient points of temporary protection and international protection, and then move on to the discussion part of our session. With that said, I will now hand over to Cillian.
Hi, folks. It's lovely to be here, and thanks to PILA for asking me. I'm just going to share my screen now. Hopefully that works. Hope everyone can see the slides, can they? Yeah. So I suppose I'm just going to give, I suppose, a brief overview of both the temporary protection and the international protection regime. And I can see, obviously, that a number of the people on the call will be people who work and practice in this area. So will be, obviously intimately acquainted with these things. But I think it's useful just to set them out because it's obviously worthwhile for us to compare and contrast the two regimes and the benefits and the drawbacks of either. The other thing I will say, and I think it's important to emphasize, very important to emphasize from the outset, is that obviously, which will soon become apparent as I speak, is that many Ukrainian nationals in particular and their family members would be capable of falling within both temporary protection and international protection. Now, the manner in which they intersect with each other is quite complicated. So I would say that in circumstances where someone holds temporary protection and wishes to benefit from international protection, that is a very, very complicated and obviously context-specific consideration, and obviously really should only be kind of entered into and undertaken really with legal advice from practitioners in the area, NGOs in the area, because obviously of the implications that choosing to do that can have. I think that's an important caveat just to I suppose, raised from the outset. I would say that, obviously it's important for us now. We're approximately 4 months in since the beginning of the conflict. And I think we're at a point now where we're beginning to see really, more of the issues that are associated with temporary protection. And I think maybe the kinks are kind of arising now that need to be worked out. Initially there was a whole of government response, which I think was very, very good and very, very strong. And the state mobilized in a manner I think we've ever seen before to facilitate Ukrainians coming to the state. But obviously that doesn't mean that, everything was perfect, but it does mean that I think that we had a bit of a reprieve for the first few months, but we're now beginning to see some of the ambiguities with the temporary protection regime arise now. So as I said, I'm just going to kind of, first of all, set out international protection, the process, the kind of reception and material conditions, and the kind of outcome for beneficiaries of international protection. Then I'm going to look at temporary protection, I suppose the scope and content of that in the directive, and then how it's been transposed into Irish law under Section 60 of the International Protection Act. And then finally, I'm just going to, I suppose, go through some of the comparisons and the approach as well that the state has taken with respect to providing material conditions under the temporary protection regime. So just to start with international protection, and these definitions will probably be familiar to many people here, but there's a definition there of what a refugee is. So obviously international protection is the term of art that we now use, and it's typically the term of art used to refer to people who are the beneficiaries of refugee status and subsidiary protection. So a refugee is a person who, owing to a well-founded fear of being persecuted for reasons of race, religion, nationality, political opinion, or membership of a particular social group, is outside his or her country of nationality and is unable, or owing to such fear, is unwilling to avail himself or herself of the protection of that country. And then obviously there's an aspect relating to stateless persons, which perhaps is less relevant. And then subsidiary protection, a person in respect of whom substantial grounds have been shown for believing that he or she, if returned to his or her country of origin, would face a real risk of suffering serious harm, and he was unable, or owing to such risk, unwilling to avail himself or herself of that protection of that country. And then serious harm is defined under the International Protection Act as meaning A, the death penalty or execution, B, torture or inhuman or degrading treatment or punishment of the person in his or her country of origin, or C, serious and individual threat to a civilian's life or person by reason of indiscriminate violence in a situation of international or internal armed conflict. So I suppose refugee is obviously more personally based, I guess. You know, we see there that it's kind of an individualized assessment. So the individual who, having a fear that is a subjective fear of something that is well-founded, so objectively well-founded, there is credible information to show that fear exists, is being persecuted, so subject to ill treatment for one of the, what are known as the 5 convention nexus, so race, religion, nationality, political opinion, or membership of a particular social group. So that last one can refer to things, for example, such as being a member of the LGBT community, and then they're outside of their country of nationality, that is, they are at the border of, for example, Ireland, and who is basically unable to return because they cannot internally relocate safely within that country, or it's not reasonable to internally relocate, and they are unable to avail of state protection. So the state is unable to stop this well-founded fear of being persecuted. So obviously, jumping out from that, we see there's a number of nexus, perhaps, that Ukrainian nationals could avail of. The 2 obvious ones are obviously nationality, which is kind of almost the poor relation of the definition, and political opinion, depending, obviously, they could be a high-ranking or a middle-ranking Ukrainian official who's being targeted by the Russian state within the conflict. So obviously, Russian nationals could certainly fall within the definition of refugee. And similarly as well, then, of subsidiary protection, you know, obviously, a Ukrainian, by virtue of being in Ukraine, could be subject to torture or inhuman or degrading treatment or punishment of a person in his or her country of origin, or the death penalty or execution, depending on their personal circumstances. Or I suppose more oppositely, you see the definition in C there, serious and individual threat to a civilian's life or person by reason of indiscriminate violence in a situation of international or internal armed conflict. So obviously, you know, a Ukrainian national would seem to almost very clearly fall within, assuming they meet the various sub-definitions within that. So obviously that they're a civilian, you know, within that definition. So international protection is in itself something that can be extended or could be extended, depending on the context, to Ukrainian nationals. So then I suppose just a really brief overview of the process, because I know many of you will know this very intimately. So as I said, and you'll have seen in the definition, for example, of refugee, you need to present, you need to be outside of your country of nationality. So you present at the frontier of the state. So typically what happens is that someone will show up at Dublin Airport, or it could even be, you know, one of the various ports in the country, and say they wish to apply for international protection. As well as that, the International Protection Office on Main Street is also defined as constituting the frontier of the state, so you can apply there as well. This is supposedly a formal application process, so you apply under Section 15 for international protection. There's a preliminary interview under Section 13 where you're supposed to, I suppose, outline, I think, in reasonably broad terms, but of course, you know, you want to be as detailed as you can, your reasons for seeking international protection. Then typically what happens is, depending on your need, you'll be referred to IPAS, the International Protection and Accommodation Service, which is now used to be part of the Department of Justice, but is now part of the Department of Children, Equality, Youth and Innovation. I might be forgetting another part of that name, but they will then kind of assign you accommodation if you need it, obviously typically in direct provision or even an emergency accommodation. And then you'll be sent out a questionnaire for international protection, which is obviously filled out ideally in the person's own language. Following that, then there is a Section 3512 interview, or there could be more than one Section 3512 interviews with an international protection officer. So, you know, obviously this is the opportunity on top of the questionnaire to set out the reasons why you are applying for an international protection. So, ideally, obviously attempting to set out why you meet either the definition of a refugee or the definition of a person with subsidiary protection. Then parallel to that process, there's also a decision that's made by the Minister for Justice, so separately to the International Protection Office, but within the International Protection Office, that's kind of they're kind of wearing two hats, I suppose, and that's under Section 49. So whether or not the person should be entitled to humanitarian permission to remain, so that perhaps you fall outside of the definition of refugee or subsidiary protection declarant, and that you should be allowed to remain in Ireland for other reasons that are humanitarian. Whilst you're progressing your application, you are permitted to stay in Ireland for the currency of progressing that application. You're given what's called a temporary residence certificate. Children are obviously then included within the application. Initially, it kind of differs then if it goes to appeal stage, depending on when the child was born. The Dublin III regulation applies, and that's the regulation that applies within the European Union to persons who have applied for or have had their details recorded by what's called Eurodac, which is the fingerprinting that happens to international protection applicants throughout the European Union. And if you've been fingerprinted elsewhere in the European Union, or if I've applied for international protection elsewhere in the European Union, you could be subjected to the Dublin III regulation, which means that you would be moved back to that country. As well as this, applicants for international protection could be inadmissible in their application, and that's typically for one of two reasons. One is that they might have been granted international protection elsewhere in the European Union. People who work in this area will be familiar that you will often get people from Italy or Greece who've been granted international protection moving on from those countries because the reception conditions in those countries is quite poor. And then the other reason is that perhaps you've been refused international protection previously. If you're refused international protection then by the International Protection Office, you can appeal that decision then to the International Protection Appeals Tribunal. If you are a national of what's known as a safe country of origin, you'll be subjected to what's known as an accelerated appeal. And that means that typically, or well, not typically, but often they will dispense with an oral hearing. Whereas in contrast, people who are not from a safe country of origin, which is Albania or Georgia or South Africa, for example, you would have a full hearing in the IPAT, kind of almost like a quasi-court setting. And then ultimately, if you're unsuccessful before the IPAT, then that's kind of the end of the line as it goes towards the substantive determination of eligibility for international protection. And I suppose the only potential recourse then is via judicial review if the decision of the International Protection Office discloses some sort of error. So then just, I suppose, briefly then in relation to the material conditions that arise from international protection. So as I said, persons who require accommodation will be accommodated in either a direct provision centre or increasingly in emergency accommodation. So the purpose is, of course, to directly provide accommodation and food to those persons. Whilst you're there, they also, international protection applicants are also given a weekly expense. So adults receive $38.80 and then children receive $29.80 per week. So obviously pretty meager. You're permitted then to work if the application is still in process at first instance after 6 months. So Ireland back in 2018 opted into the Reception Conditions Directive following decision of the Supreme Court, which said that the absolute bar on applicants for international protection from working was unconstitutional. So the state chose to opt into the Reception Conditions Directive, which, as well as facilitating an eligibility to work after 6 months, also substantively provides rights to things that in many instances the state was providing anyway. So for example, obviously persons who were unable to pay for or afford their own medical care would be entitled to a medical card and medical services. And then obviously children obviously would have a constitutional right in the state anyway to education, primary education in the first instance, but then obviously not if they proceed on to to tertiary level education. I think there were possibly rumorings about, I think the Green Party wanted to change the approach in certain circumstances to that. But they cannot leave the state then while the application is in process. That is, unless they hold another permission at the same time, which it obviously wouldn't be that many people, or else they probably wouldn't be applying for international protection without the permission of the minister. So just substantively then, if someone is declared a refugee, or if they're declared a person eligible for subsidiary protection, a refugee is provided with a renewable permission that needs to be at least 3 years long. So that's set out in section 54 of the Act. They would then be entitled to social welfare, employment, education, medical care, largely on the same basis as Irish persons. They're entitled to apply for narrow family reunification under the International Protection Act. So that's primarily just core family members, for example, spouses prior to having sought international protection, children under 18, significantly narrower than the previous regime of family reunification under the Refugee Act 1996. Eligible to apply for naturalization after 3 years from the date of application. And I think the rationale for that is that refugee status is declaratory in nature. So in recognizing you as a refugee, the state is recognizing that you were a refugee from the point of your application onwards. And so that should, err in your favor towards naturalization. They're eligible to apply for an Irish travel document. Ireland is a signatory to a European convention falling under the auspices of the Council of Europe that allows for visa-free travel for refugees to certain European countries, for example, Germany and Spain, obviously for short-term visits, not for moving. And obviously, of course, a refugee cannot, whilst their declaration is in force, return to their country of origin, because that could be deemed to be the person re-availing of state protection if they feel as if they can return safely to their country of origin. Subsidiary protection that is broadly similar, but I suppose the two key differences is that they may, depending on the content of their subsidiary protection, return to their country of origin, because obviously it's slightly different than the definition of refugee, and then naturalization arises in the normal course after 5 years. So I suppose that was, very, very, very broadly and very, very quickly. And unfortunately, I can't do it any more details than that, but of course, feel free to ask questions on that regime. But that was broadly the international protection regime, kind of a whistle-stop tour. And moving on then, I suppose, to the Temporary Protection Directive. And very, very quickly, just a very brief background, because I think it's quite interesting and useful to know. But ultimately, the Temporary Protection Directive, which of course is a European Union directive, was actually primarily motivated by the Balkan War. There was council conclusions in around that time in the early 90s. And then fundamentally, then it was adopted by the Prodi Commission in May of 2000, and then took effect from July 2001. And it was never actually activated by now. And we'll talk about the activation process in a moment. And then Ireland opted into it because obviously Ireland then, and still does, kind of has an opt-out in the area of justice and home affairs. So had originally not been a participant in it, but then in April of 2003 was. And then this was obviously placed kind of substantively into law in the 2015 Act. And I suppose temporary protection is broadly a part of the what's known as CEAS, or the Common European Asylum System acquis. So obviously we have the Qualification Directive and the Procedures Directive, and those are the European Union laws that underpin our International Protection Act. The Temporary Protection Directive is similar. It forms part of that system. And there's just a few quick figures there, just I suppose to put it into context. So the Commission originally estimated that a possible figure of between 2.5 million and 6.5 million people may be displaced, of which between 1.2 and 3.2 million may seek international protection. Back in March, the UNHCR estimated up to 4 million people may flee Ukraine. In and about late March, early April, that had surpassed 3 million, and 10 million were internally displaced. And the state originally estimated that about 2,000 people will come here. And apparently it's approximately now 35,000 people to date. And obviously the figures are primarily female, so 70% female. And that's obviously a reflection of the fact that there's compulsory conscription in Ukraine to deal with the conflict. So yeah, just some of the definitions, similarly to those in the international protection acquis. So temporary protection means a procedure of exceptional character to provide in the event of a mass influx or imminent mass influx of displaced persons from third countries who are unable to return to their country of origin, immediate and temporary protection to such persons, in particular if there is also a risk that the asylum system will be unable to process this influx without adverse effects to its efficient operation. Then the definition of displaced persons means third country nationals or stateless persons who have had to leave their country of origin or region of origin or been evacuated, in particular in response to an appeal by international organizations, and are unable to return in safe and durable conditions because of the situation prevailing in that country, who may fall within the scope of Article 1A of the Geneva Convention. So that's the definition of a refugee, or other international or national instruments giving international protection, in particular, persons who have fled areas of armed conflict or endemic violence, and 2, persons at serious risk of or who have been victims of systemic or generalized violations of their human rights. So you can see there's a lot of similarities really with the phraseology used, very, very similar phraseology used to both refugee status and subsidiary protection. And obviously there's an express nod there to the definition of a refugee, which originally was from the Refugee Convention, also called the Geneva Convention, Article 1A of that. And then we can see too, there's also reflections then of subsidiary protection, so persons who have fled areas of armed conflict or endemic violence. So obviously the definition of temporary protection kind of envisages this idea that because of the numbers of persons, protection will be provided. So it's, the concept of temporary protection is obviously primarily humanitarian, but also logistical. This idea that if loads of persons present at the frontiers of member states, that they simply will be unable to properly process those persons as would be required in an individualized context under the international protection regime. So it's obviously this idea that, well, we want to kind of provide protection to these people broadly and quickly rather than allow that to happen. So then the procedure for the activation of temporary protection is that the Commission proposes this under Article 5 of the Temporary Protection Directive, and then the Council has to formally adopt or recognize the existence of the mass influx requiring temporary protection by qualified majority voting. So this was done through Council Implementing Decision 2002-382, and the definition there then of who is a beneficiary of temporary protection is provided. So persons who are displaced from Ukraine on or after the 24th of February as a result of the military invasion by Russian armed forces that began on that date, including A, Ukrainian nationals residing in Ukraine before the 24th of February, B, stateless persons and nationals of third countries other than Ukraine who benefited from international protection or equivalent national protection before the 24th of February, and C, family members of the persons referred to in points A and B. Now, the directive allows member states individually to provide protection to a broader number of people under Article 7 and Recital 14 of the implementing decision. So it doesn't have to be just those 3 categories. It can be broader if member states wish. And then I suppose the temporal scope then is that originally under Article 4, it will be for a period of 1 year, and that's extendable then by 2 periods of 6 months automatically. And then unless it's terminated, that is, prior to that. And then it can be extended for 1 further year, bringing it up to 3 years, again, by qualified majority voting by the European Council. And then Article 6 then provides that it's terminatable, so temporary protection will end if the situation permits safe and durable return, respect for human rights and fundamental freedoms, and of course, respect for the principle of non-refoulement. So that's the prohibition of return of a person to a situation of ill treatment. So that's what's known as a peremptory norm of international law, which is a kind of a foundational aspect of the international protection acquis in the European Union, this idea that if someone is at risk of ill treatment in a country, you are not allowed to return them regardless. So yeah, just the content then of temporary protection, just a few kind of important aspects. So Article 3.1, temporary protection shall not prejudge recognition of refugee status. So, obviously shows there the kind of the interaction between the two. Article 3.3 provides that temporary protection the directive provides minimum standards. So member states can provide more generous standards if they wish. Residence permits and visas must be, the formalities must be reduced to a minimum. Access to information on temporary protection in a language they understand. Access to employment, self-employment, adult education. Article 13 then is an important one, provides for the material conditions. Member states shall ensure that persons enjoying temporary protection have access to suitable accommodation, or if necessary, receive the means to obtain housing, make provision for necessary assistance in terms of social welfare, the means of subsistence, as well as medical care. Persons enjoying temporary protection are engaged, where they are engaged in employed or self-employed activities, account shall be taken in fixing the proposed level of aid of their ability to meet their needs. And then obviously specific provision for persons with special needs, such as unaccompanied minors, those who've been subjected to torture, rape, or other serious forms of psychological, physical, or sexual violence. So that's those are the kind of the meat really of the directive, the substantive material conditions the state is supposed to provide. So then a few more. Article 14, education for minors. Member states may allow adults access to education. Article 15 then provides for family reunification. So the directive itself provides for, you could say, kind of compulsory core family reunification. So your immediate family, your spouse, unmarried stable partner, minor unmarried children, and then extended family members is not compulsory, but member states can extend it if they want. So close relatives who live together as part of the family unit and who are wholly or mainly dependent on them. Now, you will have seen that the implementing decision actually defines the scope of international protection as including all of these anyway. So both core and extended family members fall within the scope of temporary protection. So member states have to provide it anyway. So the distinction doesn't actually matter. Article 16 then sets out in relation to unaccompanied minors. Article 17 then says that beneficiaries can lodge an application for asylum at any time. The examination not processed before the end of temporary protection shall be completed after the end of that period. Member states may provide that temporary protection may not be enjoyed concurrently with the status of asylum seeker. Where international protection is not granted, member states shall provide for that person to enjoy temporary protection for its remainder. And we'll see in a bit under section 60 is that substantively, Ireland has decided not to allow people enjoy both temporary protection and international protection at the same time. But Ireland would be obligated, where someone applies for international protection and gets refused that, to still allow them to avail of temporary protection for the remainder of the period of temporary protection. And then if you're excluded from temporary protection or family reunification, you are entitled to mount a legal challenge. How one would do that in Ireland is at the moment unclear. Probably most likely via judicial review, probably is probably what most people would probably think. There's some miscellaneous provisions there in relation to removal of beneficiary from another member state if they go there without authorization. So there's an ability for one member state to remove someone who comes to their member state without permission back to the country where they had temporary protection. Now, I'll speak about this in a moment, but member states have actually agreed not to apply that article. Article 15 then relates to family reunification, inter-member state transfers. So obviously, if you have a family member in one country and you're in another, you obviously should be facilitated in one person going to the other or vice versa in order to everyone be in the same place. Exclusion there, you can be excluded from temporary protection in certain circumstances, which are set out there. So section 60 then transposes temporary protection directive, and effectively section 60 is applied by section 60 subsection 2 to displaced persons following adoption by the council, which obviously happened, who the Minister for Justice gives permission to enter and remain and who have been registered. Subsections 3 to 5 relate to excluding someone, obviously for the reasons set out in the directive itself from temporary protection. Subsection 6, permission to remain, and then an entitlement to a free visa or transit visa to come to the state. So obviously, the minister has very early in the conflict suspended the need for visas for Ukrainian nationals, which they previously would have required to come to the state. Permission for 1 year, which is renewable. The permission is revocable if temporary protection is terminated, if a person is excluded, or if they're transferred to another member state. And then subsection 10 says, and this again is I suppose the meat of it, just in this one subsection, they're entitled to seek and enter employment, access education and training to the like extent in all respects as Irish citizens, receive social welfare benefits and medical care and the same conditions as Irish citizens, same right of travel in the state, within the state that is, as Irish citizens. Now, obviously, there's no mention there at all of suitable accommodation or the means to obtain housing, which obviously we looked at in the directive itself. One could say that arguably that falls within social welfare benefit, but it's not explicit there. And then subsection 14, temporary protection shall not apply to a person who is, for the time being, an applicant for international protection, and a permission to reside in the state given under subsection 6 shall not be in force in relation to such a person. So that's the state exercising the option under the Temporary Protection Directive to not allow people to hold both temporary protection and international protection at the same time. It would seem that subsection 14 operates that should someone apply for international protection under section 15 of the International Protection Act, if they apply for international protection, then they would cease to fall within section 60 by operation of law, which obviously would, because of the definition of subsection 62, mean they wouldn't be able to avail of subsection 6, 7, or 10, the substantive material conditions flowing from temporary protection in the state. So temporary protection, then, just the kind of material conditions very, very quickly. So you'll have seen that typically access to services is being provided at the airport. The Department of Children, Equality, Youth and Innovation has kind of set up, I suppose, a kind of a station there to provide access to the material conditions of temporary protection upon arrival, because that obviously, the airport was the place by which most people were arriving. Issued with a PPS number on arrival, given a confirmatory permission letter on arrival for a number of people who arrived before the 24th of February, which the minister had previously indicated, and I think is still the case, that they would still be able to avail of temporary protection, even if they didn't strictly fall within the scope set out under the implementing decision. They would not have had this letter, but I suspect that will be regularized, or possibly is already being regularized. They're being placed, so again, similar to international protection applicants, they're being housed by IPAS in emergency accommodation, and most people would have seen that in the news, as well as with volunteer families, or obviously, Ukrainian nationals might have a support network that existed already in the state, which is possibly part of the reason why they came here. So they can obviously stay with them. I think there was currently no need to register that permission under Section 9 of the Immigration Act 2004. I imagine possibly, depending on how long the conflict goes on, that could change. They're entitled to access social welfare supports, child benefit, job seekers allowance, one parent family payment, disability allowance, carers allowance, the state pension, the SWA, rent supplement. Interestingly, the Department of Social Protection considers that Ukrainians satisfy the habitual residence condition, which is why they can avail of these social welfare supports, unlike applicants for international protection who are not considered to satisfy that. Whether that makes sense consistently is a different question, but that's the approach, for the better, presumably, that the department has taken in relation to people with subsidiary protection anyway. They cannot avail of the housing assistance payment, and the reason for this is because obviously IPAS is the one tasked with housing them, so they are considered to be able to avail of they're considered housed effectively, and not having a social housing need as set out under the Housing Miscellaneous Provisions Act. So that's part of the reason why they cannot avail of HAP. Finally, then, this is a question that comes up quite frequently. If you have temporary protection, you can leave Ireland and avail of temporary protection elsewhere in the European Union. So recital 15 of the implementing decision disapplies Article 11. So that's the article that basically says that a member state is allowed remove someone back to a member state in which they hold temporary protection. If you have someone in that situation, it's probably best to engage with the department and probably also engage with the relevant authorities in the member state in which that person wishes to go, because you're not allowed to hold temporary protection in 2 member states simultaneously. So if you leave to go to another member state to avail of temporary protection there, your temporary protection in Ireland, for example, is supposed to terminate then. As well as that, just something additional is that Ukrainian nationals who hold biometric passports are entitled to travel freely within the European Union anyway. So, for example, if a Ukrainian national wished to go to Germany for 3 or 4 weeks to visit, if they have a biometric passport, they are allowed to do that. That continues on. So that applied throughout the Schengen area. Ireland was actually the exception, one of the exceptions in requiring visas for Ukrainian nationals. So Ukrainian nationals have up to 3 months to travel within the European Union, well, the Schengen area anyway. So there's very finally and very briefly then, because I think I've been banging on for too long, just a kind of a very quick overview of the contrast then. So temporary protection is somewhat quasi-declaratory. So if you fall within the definition set out in the implementing decision, you can avail almost automatically of temporary protection, whereas international protection is dependent on an application process and an individualized assessment. There's immediate access to employment with temporary protection, whereas obviously after 6 months with international protection, access to social welfare for temporary protection beneficiaries on the same basis as citizens, whereas obviously those who are placed within the direct provision system are entitled to that allowance. Temporary protection is up to 3 years in scope, and it's terminatable before that. And one thing I will say is that if we get to the end of that 3 years, there will need to be another commission proposal and council decision in order to extend temporary protection. Now that's separate to anything Ireland may choose itself. If we were approaching some sort of cliff edge with the 3 years expiring, but just to note that that process needs to start again for temporary protection. Whereas obviously, if you are a person who holds international protection, your permission is renewable up until the point. Well, you don't have to naturalize obviously if you don't want to, but your permission is ultimately renewable. So temporary protection beneficiaries obviously will maintain and keep their Ukrainian or their other passport if they're, for example, if they're a family member of Ukrainian. Whereas if you have refugee status, obviously, you know, you're basically saying I cannot return to my country of origin because of my risk of persecution. So you obviously don't get that. Family protection, or sorry, temporary protection. There is, I suppose, a wider beneficiaries who can avail of family reunification there because it's defined within the implementing decision, whereas for international protection applicants, it's a far narrower cohort of, you know, family who can avail of that. Temporary protection, you know, they're given effectively a 1 year renewable permission, possibly could be longer depending on what approach the state takes. Whereas for persons who hold international protection, that has to be at least 3 years. So persons with subsidiary protection are typically given 3 years, and persons with refugee status are typically given typically 5 years. And then obviously in relation to accommodation, then persons with temporary protection are being housed, I think, in a mixture of hotels and emergency accommodation. There's now talk of modular housing as well as with volunteer families. Obviously, whereas if you're an applicant for international protection, you are placed in direct provision or in emergency accommodation. So that's it. I mean, that's kind of, I've tried to give a deal with a huge amount, I think, in quite a short amount of time. But apologies for going on for so long. But that's, I suppose, kind of a very broad, you know, overview of the system, of both systems, in an attempt to kind of compare and contrast the approach that's taken to them. But if anyone has any questions, you know, feel free to ask me now, or alternatively, my email address, which I've stopped sharing, but my email address was there. Feel free to contact me directly if anything arises too.
Thank you very much for that, Cillian. As Cillian said, we're going to open up the session for discussion now. If you have a question, you can use the chat function, or if you prefer to raise your hand. Yes, I see there's a hand raised. Ursula.
Yeah, it's an issue around refugees and their permission being renewable. I've often seen clients coming into us with IRP cards, sometime for 1 year, some of them they're for 3 years, and I've seen 10 years. So I always thought their permission letter, if you have refugee status, that's it, like, while they renew the card, but I can never understand why some of them, and also with travel documents, there's no consistency on whether it's 1 year, 3 years, or 10 years, maybe 5 years, you know? So do you know anything about that at all?
Yeah, no, it comes up all the time, I suppose. So Section 54 of the International Protection Act actually says, it expressly says that what are called qualified persons, which is kind of an umbrella term for people with refugee status and people with subsidiary protection, they are supposed to be given a permission for at least 3 years in the first instance. Now, often going beyond that, it can really vary and is almost entirely up to almost the GNIB officer that they draw when they're trying to register or renew. It is completely random for some reason. It sometimes, I think, shorter permissions sometimes could be as a result of someone not knowing that it has to be a minimum of 3 years. But I mean, I think that if you come across someone who has in the first instance been given a permission for less than 3 years, then they absolutely should be entitled to a 3-year permission minimum to begin with. But yeah, no, I agree. It's a bit bizarre. I don't understand.
Yeah, you would expect people in those offices to know their job.
To know what they're doing. Yeah, you would. Yeah, I can't disagree with that. Yeah. But yeah, it's actually kind of unsatisfactory, obviously, because you have people placed in this kind of slightly, they could be confused as to the currency of their permission. They don't know, and that places kind of a lot of stress on them and frustration, which is very understandable.
Yeah. I think just the other point is, I think it was really good to get the difference between the temporary protection and international protection, because there's been a lot of talk and hearing comments, and even from some of the clients, well, the Ukrainians are getting everything,
Yeah.
I think the Ukrainians need to be looked after, but so does everybody else. But for me, also, it was good to have that clarified, that it's under EU law, really, that, and Ireland have signed up to that, and it is quite different too.
Yeah, no, it is. It's unfortunate, and I mean, like, the fact of this being the first time that the Temporary Protection Directive has been activated, in spite of, if we think back to the Syrian war, things like that, is kind of in many respects appalling, and just there is a very clear disparity in treatment there, which is extremely unfortunate. But if only there had been the kind of the political will when those conflicts began to provide the same level of protection that we currently do to Ukrainians.
Do we have it? Oh, there we go. We have another question, a hand up.
Hello, my name is Maya. I'm a Ukrainian myself here in Ireland under the temporary protection. You talked about Ukrainians not being registered now. So yeah, really, we do have the temporary protection letters, and for example, the authorities say that it's for now just enough to stay in the state, but there are some talks about maybe Ukrainians will be issued the residence permission cards in like the nearest future. And I just wanted to get your opinion on how could it be done, because for example, now the temporary protection initially it lasts till March of the next year. So if we even start the process now, so the cards would be issued for only like several months, for example, and the system is overloaded anyways, and we have no idea about would the temporary protection be prolongated. And if I'm not getting it right, so there is no need of the vote of the European Council vote to prolongate now for the first for the second year to prolongate the temporary protection is just needed to, yeah. So maybe just your thoughts on all the registration situation and cards issuance.
Yeah, no, you're completely correct. Yeah, so obviously the currency of the first year of temporary protection would obviously bring us up to around March of next year, and then it will extend automatically for two further periods of 6 months, unless it's terminated before that. But yeah, I think the question of registration is an interesting one, and obviously I think the reason why persons with temporary protection weren't being expected to do it is because of the numbers, obviously, and because I think of the very well-known chaos in registration anyway. I mean, your guess is as good as mine. It could be, I suspect what could happen is that the state will probably take its own view as to allowing Ukrainians to remain regardless of temporary protection for a specific period, and that might help facilitate them ultimately in registering them, because I think at some point the state obviously does have an interest in knowing, reasonably precisely how many Ukrainians are availing of temporary protection in the state, just for its own internal planning, obviously. But yeah, that could be one solution to it, but honestly I don't know. They might simply decide just not to register them. I mean, that could be the easiest option. Or they could attempt to do it perhaps in different waves and trigger, send out letters to Ukrainians at different points. But again, it's a logistical nightmare. But yeah, your guess is kind of as good as mine.
The decision of not registering Ukrainians is in the discretion of the Irish state, for example, because it's mentioned in the directive that people should be registered. But is it?
Yeah, well, I suppose the directive and section 60 refer to registration in a different way than we speak about registration for other nationalities in Ireland. So, anyone who has a stamp 4 permission, say on the basis of their marriage to an Irish national or their parentage of an Irish child or whatever it is, their obligation to register arises under section 9 of the Immigration Act 2004. And that's a facility for the state to do two things. One, to maintain the register, and two, to charge fees, basically, is probably the main reason. Whereas the obligation to register that arises under the directive and under section 60 is a different obligation. So the state could be taking the position that the issuance of the permission letter feeds into their own separate registration process for people benefiting from temporary protection, but that's a separate question to the section 9 registration. The extent to which the state can dispense of section 9 for Ukrainian nationals is again unclear, and obviously the state can't charge them for permission anyway. But yeah, they are slightly different. But I would say it's probably in everyone's benefit at the moment that you aren't subjecting Ukrainian staff to register. But yeah, it is a bit unclear, to be fair.
Thank you. Do we have any other questions? Sansha.
Yeah, my question is in relation to the non-EEA spouse of Ukrainian nationals with TPD. Are they entitled to apply for family reunification?
So I suppose the extent to which that's a very interesting question, because I suppose in the first instance, the directive basically says people with TPD are allowed to apply for family reunification for core and extended family members. What makes it slightly more confusing is that the implementing decision of the council has included those core and extended family members within the definition of who can avail of temporary protection in the first place. So whether a person who falls within the Temporary Protection Directive only by virtue of the fact that they are a family member of a Ukrainian national can avail of further family unification is unclear. I would say potentially not, just because of the manner in which you would be interpreting the various sections. I mean, it's always worth trying, but it's definitely unclear. There probably is an argument to be had that basically because they fall within the implementing decision, they are entitled to the further family reunification within the directive, but it is unclear. It is very unclear. I couldn't probably give you a definitive answer without spending some time thinking about it, but I think you've flagged a very unclear, the European Council was probably attempting to be as generous as possible in drafting the implementing decision, but that has led to this kind of further confusion whether someone who isn't a Ukrainian national or who doesn't fall within the TPD can avail of that further family unification. So I can't give you a firm answer, but I would possibly say it's kind of erring towards the no.
Okay, any other questions, anybody? We have a few minutes left if anybody has any questions. If not, oh, we do have another question. Ruth Halen.
Hi, yeah, I do just have a quick question, and thanks again for the talk. I just have a question around the process of state expanding the scope of temporary protection and who's included. If there is any further guidance under the directive as to how they go about doing that. I mean, from the Irish perspective, it seems like it's just an update to the FAQ document, and is that essentially it? Like, I mean, is it just what's the story there?
You've hit on again a kind of a fascinating part of it, which is so the directive itself simply says a member state can extend the personal scope to further people if it wants.
Yeah.
No, it's a discretionary power, and it's up to, because it's a directive, it's up to the member state themselves to do that in conformity with its own laws, however it wants. Arguably, they could have done that anyway. It didn't need to be explicit in the directive, but it was good to have it in there, I guess.
Yeah.
Now, Section 60 then only provides temporary protection within Section 60 to people provided with temporary protection under the directive. So the extent to which a person is actually being provided with temporary protection is very unclear. I mean, the state obviously has a residual power, a residual executive discretion to allow whomever it wants in. The minister has this executive discretion, which one could say is the foundational basis for allowing people who are beyond the scope of the directive in, because unfortunately Section 60 was drafted quite poorly and doesn't recognize that it could be extended by the member state themselves. How the state chooses to do that is kind of up to the state itself. Obviously there's many Ukrainians here who would have come before the council implementing decision, which means that they actually technically don't fall within the directive, but the state has just treated them similarly to other Ukrainians anyway. It's often best not to ask about the reasons for that. Lest you pull the rug out from underneath anyone else. But if the state were to want to add further people, it's kind of a matter for, probably the easiest way and the least cumbersome way is for the minister simply to say, well, I'm just going to exercise my ministerial discretion to let in these categories of persons. There doesn't need to technically be a piece of primary legislation.
I suppose I'm just curious, I know it hasn't happened yet, or may not happen at all, but if they extend the scope and then restrict the scope later on, how freely can they do that? Presumably they freely enough.
I suppose in circumstances where, like, for example, if you were a Ukrainian national who came to the state having fled Ukraine prior to the 24th of February, those people, and the minister was like, well, I'm just going to treat you the same as any other person who availed of temporary protection. I've even given you one of those letters. I would imagine those persons would have a legitimate expectation to be treated consistently for the currency of temporary protection. So I think the state would be in extremely dodgy legal territory if it were to suddenly say, actually, we don't want you anymore, go back. But I suppose it just kind of your example, I think, shines a light on how the lack of clarity isn't ideal either, but effectively it's just a matter for the minister to decide if he wants to do that or not.
Perfect, thank you.
Thank you for that. Does anybody else have any more questions? Okay, it seems like nobody else has any further questions. So thank you, everyone. That was an excellent session, I think. If you need to get in contact with us, you can email pila@flac.ie. And lastly, thank you once again, Cillian, for your time and expertise.
Well, thanks, everyone.
Thanks, everyone.
Thanks.
Bye.
Bye.
Thank you.